In February of 2016, Judge Leticia Astacio was arrested and charged with driving while intoxicated after causing a three-car collision on the way to court. She attempted to use her position to influence police and was ultimately sentenced to 1-year conditional discharge. She ignored court conditions and continued drinking and left the country for an extended vacation in Thailand. She continued to draw a salary. Ms. Astacio was also found to have violated multiple rules of judicial conduct, including presiding over a previous client's case and attempting to transfer his case in a favorable manner. During multiple other cases, Ms. Astacio made, and I quote, discourteous, insensitive, and undignified comments before counsel and litigants in court. After sustaining 6 charges of misconduct, it was ordered that Ms. Astacio be removed from her judicial office. She has taken this decision to the New York Court of Appeals, arguing for a sanction reduction from removal to censure, meaning her violations would be recorded, but she would not be removed from office. Let's take a look.
Number 94, the matter of the Honorable Leticia D. Astacio. Counsel?
May I reserve, Judge, 2 minutes for rebuttal?
You may, sir.
Thank you.
You're welcome.
It is my honor to represent Judge Astacio, who is present here today. We argue that Judge Astacio should not be removed from the bench. She is remorseful.
Before we go any further, I just want to be very, very clear about what it is you are seeking. You are not disputing any of the findings of fact or the fact that the charges were sustained to the extent that they were sustained, but merely arguing for a reduction of sanction. Is
Yes.
that correct?
Yes.
Okay.
So is it your position that Ms. Astacio's limited judicial experience should somehow mitigate her conduct on the bench?
As to certain of the charges, yes.
Which charges, sir?
Well, to make a distinction between the on-the-bench charges, if you will, to lump it into that category, and the violation of the conditional discharge, I'm not going to argue that the conditional discharge violations were anything but poor judgment on her part. There were 2 violations, which I thought she explained eloquently at the hearing. The first, she did not read carefully the conditional discharge component that required her not to drink alcohol. It's like doing an autopsy.
Does she have to read it carefully? Or, I mean, first of all, it seems to me that anybody, and particularly a judge, would want to read those conditions very carefully. In this particular case, the judge actually, as I understand it, presided over DWI cases, so she even had more reason to be familiar with those types of conditions. So that seems like a little bit of a shaky.
Well, Judge Stein, let me say this. This is a form that was used by some judges and not other judges. And I'm not here to tell this court that Judge Astacio was not familiar with the form per se. What I am saying to you is that I believe, and I think the medical records demonstrate, this was a traumatic event for her, reading in detail what happened to her. She should have done it. She acknowledges she should have done it. She apologized to the commission 9 times in her 10-minute.
Can I ask, was the requirement not to consume alcohol or not to consume alcohol and also not to drive while under the influence of alcohol? What,
Yes.
just to be clear, what were the conditions?
Oh, yeah, thank you. The condition was not to consume alcohol.
Then it made no mention of driving while under the influence?
It's a conditional discharge, and so I think implied is that one should not drive also under the influence.
Correct, perfect. So then when she got behind the wheel and didn't pass the blow test?
Yes.
How,
Oh, I'm sorry. I didn't mean to
no.
interrupt.
Doesn't that already show that regardless of whether or not she had read the document, that she was not complying?
Right. So I would refer the court to page 369 of the record. As to that issue, she was present with her aunt. The requirement, as I understand it, is she is to blow, and then the other person is to drive if she passes the blow, what you do when you don't pass the blow. I'm not exactly sure. In this instance, she failed. So I would respectfully argue, Judge, that her intent was not to drive.
What are the other mitigating factors in addition to the, as the Chief Judge already mentioned, the lack of experience, judicial experience? What other mitigating factors?
Well, I think one of the important mitigating factors here is that this judge, she violated a conditional discharge that, and took a trip. She had arranged to be contacted by her attorney by email. For whatever reason, he left a message for her by cell phone, and so she was not aware in real time that Judge Aronson on May 15th had required her to be present and take a test to ascertain whether or not she had been consuming alcohol.
By
So-
that time, did she know that she was under a continuing requirement to take tests as directed?
Well, the conditional discharge, and I say this respectfully to that court, I'm not here to point the finger at them, but it's not exactly clear that she can't travel or can't be away in the conditional discharge.
Right, so it's not like very often on probation or parole, there's a condition that says you can't leave the state, or sometimes even the county, without permission. I get that. I want to go and focus on the difference between a removal and a censure. And in the cases where we have approved a removal, it's because there's a belief that the judge has lost the public confidence irretrievably. So what evidence in this record would lead us to conclude that that is not the case?
I think there are several components of evidence. First of all, you have her biography in the record. As she was elected by as the first woman of her ethnicity to the bench in that community. Second, you have the very clear demonstration by the judge that she is remorseful, and I have to say this, when she was trying to express to the commission her remorse, she was interrupted, and she was, and introduced into the proceeding was a statement that the chair of the commission apparently had read or seen, or thought he had read or seen.
Is there any evidence as to that, that in fact that commissioner, or indeed any of the commissioners, took that into account in determining the sanction?
Well,
Or as I understand it, it was expressly stated that they would not and did not.
Judge, that would be a difficult thing to prove, but let me say, the statement speaks for itself. The statement, if it is to be believed and uttered, reflects contempt on Judge Astacio's part for both
Well,
the
I
body.
thought it was just calling into question her sincerity in something that she had said.
Well, no.
And I'm not suggesting that it was appropriate,
Oh,
by the way.
thank you. Well, may I just finish by saying to you and to the other members of the court, that statement not only suggested that she had contempt for the body, but also contempt for the rule of law. That was central to our argument in front of the commission. What we were attempting to demonstrate, what we were attempting to say to the commission is, we're a young judge, we're only 37, 38 years old, and we understand that we've made mistakes, and there was sort of a cascading of mistakes, but we have not done or engaged in conduct that the people who this court has historically removed, that conduct. We have
Well,
not.
But the court has recognized that driving under the influence is a serious, grave matter, correct?
Correct.
And so it's
remove-
not once, it's more than once, or at least more than once that she attempted to do so post the misdemeanor, right?
Judge, I think that's a question of fact in the record. I refer you back to page 369, but there is no question, Judge Astacio acknowledged that she recognizes that driving under the influence is indeed a serious offense.
Let me ask this.
Yes, Judge Fay.
Mr. Julian, in the cases where judges have been pulled over, gotten DWIs, but haven't been removed, they've acknowledged that they're alcoholics and they've gone to AA. Usually there's been that kind of proof in the record. Do we have that kind of proof in the record here with Judge Astacio?
What we have in the record, and there are exceptions, Judge Fay.
That's fine. I bow to your superior knowledge in that, trust me. No, but I just want to know, in this case.
In this case, we put into the record the analysis of her psychologist who pointed out that she was engaging in anesthetizing
I saw
alcohol.
that. So let's assume that's true, but she didn't say she was an alcoholic, I think, and I thought the psychologist said something like some mild cognitive disability related, and that alcohol was used under moments of stress.
You have it pretty much, but she also went through 2 outpatient alcohol programs, one finding her to have a mild alcohol abuse disorder.
Okay. Has there been a public acknowledgement that I'm an alcoholic, I was wrong, I shouldn't have done this?
Yes, throughout an alcoholic, I cannot say that.
No. Okay.
But what I can say is a public acknowledgement and 9 times to the commission in 10 minutes.
Thank you, counsel.
Thank you,
Judge.
Mr. Julian.
Good afternoon, Chief Judge DeFiore. Good afternoon, Your Honors. May it please the Court. On October 3rd, 2016, just 6 weeks after the petitioner was convicted of driving while intoxicated, she attempted to commit the same crime again. She admitted in her testimony that she had 4 glasses of wine, 3 shots of tequila. She was drunk. She shouldn't have been driving. And yet she admits that she got in her car and she attempted to start and to operate the vehicle. Only her court-ordered ignition interlock device stopped her from doing so again. There are a lot of aggravating factors in this case. There really are a lot of them, most notably that she was incarcerated for violating a court order. But I think this incident...
Does that go to the public confidence? Is that your point on that?
You said in Quinn the notorious involvement with the law was a factor, and I think you have that here in droves.
So a judge who has a DWI and happens to make the news is more subject to removal than a judge who does the same thing, but
The judge has no
it's not
control
a good
over what the
day.
news does, Your Honor. I understand where you're going with that. No, a judge is responsible for her conduct. When a judge commits crimes that are newsworthy, it has an impact on public confidence. You have never had a judge who was incarcerated for violating a court order and went back on the bench, and it would be unprecedented to do that here.
Absent the DWI, are the other charges on their face enough for the removal?
Well, I think that the DWI with the multiple aggravating factors and the 2 violations of the conditional discharge, we consider those as a package. If you're asking about charge 4 and charge 5, which are the on-the-bench conduct, we concede in the brief that those are less egregious, but I think they show a certain amount of lack of impulse control that you see through these other charges. The comments about the buyer's remorse were really uncalled for. And she's not accepting responsibility for that. She's trying to
Counsel,
say...
how can we be assured that the chair's comments didn't prejudice the commission's determination?
You can read the determination. The determination at every turn points to record evidence in support of the findings of fact and the conclusions of law that they made. And really, how could it not? I mean, the DWI and the Thailand violation were established after trial and upheld on appeal. She admits to the first violation. She admits that she was rude and profane with the police officer. She admits nearly everything that you would need to find removal, regardless of what she said. In terms of her remorse or accepting responsibility, you have her own brief to this court. She says she accepts responsibility, except she didn't really do it. She accepts responsibility for having been convicted of DWI, but she wasn't drunk and she was wrongly convicted. She's sorry that she spoke profanely to state troopers who were just doing their job, but they provoked it. And now you have an argument in her reply brief, which I was really quite surprised to see, and counsel mentioned it, an argument that she didn't really intend to drive on October 3rd, that her aunt was going to drive. What's surprising about that is surprising on several levels. First of all, it's an argument that appears for the first time in the reply brief. It's not in her main brief to this court. You won't find it in the briefs to the commission or to the referee. You won't find it in her statement that she made when she appeared before the commission. And it's completely at odds with her guilty plea. She stood in open court, and it said page 870 of your record, and she admitted that she attempted to start and to operate the vehicle. And then she goes on, there's pages of her explanation for how that happened, and it's all about how she didn't read the conditions. She says nothing about the fact that she didn't intend to drive. The fact that she's raising that defense now in a reply brief for the first time is evidence that she's still not willing to accept responsibility.
Did she seek mitigation on the basis of some alcohol abuse problem or difficulty or challenge?
Well, there's no medical evidence here to support alcoholism, but let me say, the disease of alcoholism is not a defense. It's an explanation. If you have a case like Landesino, in which there's substantial medical evidence that a judge suffers from a disease, and there's also substantial evidence in the form of multiple people who come in and testify about the judge's efforts to rehabilitate himself and to conquer his disease. The commission in that case said, we would remove this judge but for the extensive evidence of rehabilitation. But if you go back to Quinn and to Aldrich, in Aldrich, there's evidence in that record that the judge had been sober for 2 years by the time it got to this court. He was an alcoholic, and nobody disputed that. But the nature of his conduct, which was being intoxicated on the bench and making racist statements.
So let me ask you this. Everything that happened, the 3 violations ultimately of the conditional discharge, if afterwards the judge had gone to Alcoholics Anonymous, gone to a program, forsworn all alcohol, came out publicly and said, as an alcoholic, I made some mistakes, but I still want to be a judge, and I think I can still serve the community effectively. In point of fact, maybe I even learned something from these experiences, and I can be a better judge as a result of them. Because some of the remarks struck me more as immature than venal. I guess that would be the way I'd characterize them. As I think one of your commissioners said, she may have been her own worst enemy. In that circumstance, do you think the recommendation might have been different?
I think, and that's exactly where I was going with Aldrich, Your Honor. Mm-hmm. In Aldrich, there was evidence that the judge had gone to AA, that he was sober, that he was no longer an alcoholic, and that was, but you said the nature of the misconduct there was, I believe you called it, of such an aggravated nature that it simply wasn't enough. You said in other cases in Bauer, sometimes no amount of contrition is enough. And in a case where a judge has gone to jail for violating a court order, who's twice tried to drive while intoxicated, I think this might be a case where even if there had been sincere contrition, it would not have been enough.
Thank you, counsel.
Thank you, Your Honor.
Mr. Julian?
Yes, thank you, Judge. First of all, this judge
Counsel, could you address the commission's, counsel for the commission's point that despite the representations that she's remorseful, the reality is that she blames others or says others provoked her or says, no, I never did that. So that she doesn't really recognize that she has violated rules or that she's done something that warrants removal.
I'm sorry, I didn't mean to speak over.
Please.
She fully recognizes that she violates rules. She had a trial in city court. She was convicted. She did not believe at the time she was driving at 7 o'clock in the morning and she was driving to the YWCA to work out. She did not believe she was under the influence of alcohol, but she accepts the verdict. She understands that that's the verdict. And this court has said that simply because a judge contests the issue, that in and of itself is not an expression of remorse. You don't check your rights at the door as a judge. She then went to 3 different programs, 2 of them outpatient, one required by the conditional discharge to address her alcohol issues. And then she has said, and again, I want to reiterate to the commission 9 times during the argument that was punctuated by the reference that I've referred to, that she was sorry, that she accepted responsibility. In fact, her words in front of the commission were, "I accept responsibility for everything." During the hearing, as to each of the charges that are relevant, including the charge dealing with her treatment of the police officer, she said she was sorry, she apologized at the station. She apologized to the police officer after she had engaged in
I understand,
torrent
but I
of
think,
abuse.
I thought counsel's point was that she may be saying those things, but then she also says, but I was provoked, and that helps to explain. I take responsibility, I shouldn't have done that, but I was provoked,
Well,
right? Or as you were saying, she blows, but it's really someone, she blows to be able to get her BAC number up, but it's her aunt who was going to drive.
Well,
And I wasn't, as you said now, I didn't think I was drunk, but I accept if that's the conclusion, and that's what he's saying, that's different from true, someone who really shows contriteness, who really says, I recognize that I was wrong.
there are always facts that underline contriteness. And if we're being penalized for trying the case to point out what exactly the mitigating factors were, I mean, you don't get to a place without walking there. And she got to the place where she apologized, but we also, in trying the case, talked about our journey. And if that is bad lawyering on my part, I plead guilty.
Thank you, counsel.
Following these arguments, the appellate court affirmed the previous decision. Leticia Astacio was removed from office. She continued to work as an attorney until she was sentenced to 6 months in jail for missing probation appointments. She was released in January 2020, and her case is now closed. Did this judge get off too easy? Let me know what you think in the comments below. If you like this video and you'd like to see more every week, please subscribe. I'd appreciate it. Until next time.